Record shall show that the jury is in the courtroom. Mr. Taylor, I understand as foreperson of the jury, you have sent us a message stating that the jury has reached verdicts in these two cases in the punishment phases of these trials. Is this true, sir?
That is correct.
Are these verdicts unanimous ones? That is, ones that are agreed upon by all members of the jury?
Yes, sir.
Do any of the jurors disagree with your foreman's representations? No disagreements are indicated. It does indeed appear to be unanimous in each of these cases. I'm going to ask you, as before, please pass the documents to the bed. If you may be seated, the court will review for proper form and publish these verdicts. The defendant shall rise. Beginning with cause number 22-39775, we, the jury, assess the defendant's punishment at confinement in the institutional division of the Texas Department of Criminal Justice for a term of 8 years. We further find that the defendant has never been convicted of a felony in this or any other state and recommend that this punishment be probated. This verdict is received and made a part of the record for all purposes, and it is signed by the jury foreperson. As to cause number 22-3977, we, the jury, assess the defendant's punishment at confinement in the institutional division of the Texas Department of Criminal Justice for a term of 8 years. We further find that the defendant has never been convicted of a felony in this or any other state and recommend that this punishment be probated. This verdict is received. It is signed by the jury foreperson and is made a part of the record for all purposes. You may be seated. Ladies and gentlemen of the jury, your duty as jurors is completed. At the beginning of the trial, I placed each of you under a number of instructions, and at this time, I am releasing you from those instructions previously given to you. One final instruction: once you are discharged, you are released from your oath of secrecy. You will be free to discuss this case and your deliberations with anyone. You are also free to refuse to discuss these cases, and you have every right to maintain your silence unless otherwise ordered to do so by me. In a few minutes, about 10 or 15 minutes, we have to conduct some formal matters based upon the decisions of the jury. And the attorneys in this case may wish to ask you questions and talk to you, and they will be here for about another 10 or 15 minutes, but they'll be outside. If you wish to ask them questions, sometimes there are some things that you didn't understand, you want clarification on, and they'll be able to come out and talk to you if you wish. You are certainly free not to discuss any of these matters, and you can head home and get on with your life in a regular basis. Ellie has documentation if you need it for work or school or other purposes that show you were here. Thanking you for your service is an understatement. Your time is not only important for all of us, but it's what the United States stands for. A right to a trial by jury is in the Constitution. And if we don't have good, fair people show up and handle those duties, then that Constitution and that flag is meaningless. You bring meaning to that by honoring your service as jurors and being good citizens. I hope to have the honor to work with you in the future. Until then, may God continue to bless Jefferson County and her citizens, and you are excused. And also, Mr. McMakin, thank you for your vigilance in holding watch. And it would have been an honor having you on the jury, but thank you again. You are excused, ladies and gentlemen. Thank you.
Just place your time.
All right, the the jurors have exited. Anything to bring up before the court renders a formal sentencing?
No, Judge.
All right. In cause numbers 22-39775 and 22-39777, the state of Texas versus Brendan Patrick Hardy. Benjamin Hardy, you came before this court and a jury, entered a pleas of not guilty to the offenses of sexual assault of a child, second-degree felonies in each of these two cause numbers. The evidence was submitted. The jury was charged by the court. After deliberating, the jury returned a verdict finding you guilty of these two offenses of sexual assault of a child. Thereafter, evidence was presented. The jury was charged on sentencing. They deliberated and returned verdicts of 8 years confinement in each of these cases. And those sentences are to be suspended and you are to be placed on probation based upon the jury decision. Anything to add before the court finalizes its judgments?
No, Your Honor.
Hold on. I don't understand what just happened there.
He was just getting up to walk inside, Judge.
Oh, you're going to go walk outside? Go outside if you need to, sir. And again, the jury assessed your punishment at 8 years confinement in each of these two cases and recommended that you be placed on community supervision or probation. If nothing further to add by the parties, the court formally states that it is therefore the judgment of this case that in cause numbers 22-39775 and 22-39777, where you were charged and found guilty of the second-degree felonies of sexual assault of a child in each case, that you are indeed guilty of those offenses and that you shall be punished in accordance with the jury's verdict. Any legal reason why sentence should not be pronounced formally and final.
No.
Finding nothing to bar the pronouncement of sentences against you, you are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice prison to serve a term of 8 years confinement in each of these cases. Those terms of confinement shall be suspended and you shall be placed on regular probation for terms of 10 years on each case. What do the parties say as to whether these sentences should run concurrently or not? Because of the rules, go ahead.
As to seeking some type of cumulative sentence, Your Honor, the state would reserve its right to assert that in the event that he violates it in probation.
And Judge, I'm not sure how that works, but I think
Me neither.
I think we are barred from
More than 10 years.
stacking 10 years on 10 years of probation.
Yeah.
But I think you, under this, I didn't mean to interrupt the court, but under this scenario, I think what Mr. Ham said is correct. If there is a violation, I think the court at that point would be free to consider stacking the 2 8s. Is that?
That's what I'm asserting, Judge.
Well, what this court doesn't want to make a mistake of is failing to make those findings at this time if those are legally necessary. If not, then the court is going to continue.
As long as you don't pronounce today that they're running concurrent, Judge, we can reassert that later.
I don't object to that.
All right, then the court will not will avoid and defer any ruling on whether these cases should run concurrently or consecutively. Now, a couple of things. The court is going to order a post-sentence report to be prepared by the probation office to provide the court with appropriate conditions and terms of probation, which are in addition to the normal and customary terms of probation, beginning with do not commit an offense under the laws of this state, the United States, or any other state, and some of the other terms and conditions of probation. I'm going to order that the defendant will report directly to the probation office, and
Judge, they leave in 2 minutes.
they leave in 2 minutes,
So it's gonna have to be tomorrow.
and
I have to email the liaison as well.
okay, I want you to report there on or before 9:00 a.m. at the probation office. And then we are going to have a hearing on terms and conditions of probation, which I want to hold as soon as possible when the parties can be ready within a week. Is that good?
Your Honor, may I understand that that will also allow the state to assert whether or not there's a time on this? I know
Okay,
it's the court's decision, but we would like to be heard on whether or not that's done.
all right.
And then the sort of counterside of that is true, obviously, too, Judge. I would assume that the court's going to sign a final conviction today, and then have the post-sentence report prepared, and we would come and meet about that. In the meantime, though, I anticipate we would be filing a notice of appeal as well. So I don't know how that impacts the initiation of probation or how that would work, but
Okay, the court is going to reserve any other terms of probation other than the defendant shall report directly to the probation office on tomorrow that there are terms and conditions of probation that are going to be set immediately, and that is you shall not leave Jefferson County, Texas until this meeting with the probation office occurs, and then we will have a hearing as soon as possible so that the court, which is deferring the conditions of probation other than do not commit any offenses, state, local, federal, and stay within Jefferson County, Texas, and have no contact with the victim in this case. But there are numerous conditions of probation that are always in probation decisions, and there will be special to the circumstances of this case and the needs of the defendant. And the court will take those up as soon as possible when the parties are ready to provide any additional information as to what the probation office's recommendations are. And whatever you want to supplement, I will consider
Yeah.
them, but the court is already has its mind made up on certain conditions of probation. It's just, I don't think it's necessary to deal with those right now.
Two additional requests, Judge.
Yes.
That there be, in addition to the no contact with the victim, that it also include any children under the age of 18.
I'm sorry.
Any children under the age of 18, we would ask that that be included because of the nature of
Okay.
this offense.
All right. And that will be immediately ordered, and then we will take up whether that will be part of the
We understand.
probation, general probation terms throughout the length of probation.
Second request, despite whether or not they're requesting an appeal, we're asking that the registration requirements and the notice be signed today.
That's ordered.
Requirements.
So that has to be done as soon as possible. There are sex offender registration requirements under Texas law. You are ordered to follow those, and as soon as possible, register under those terms. I don't know if full registration can be done today, but it will be ordered as soon as possible.
We understand.
If you're unable to today, tomorrow morning. What else?
Those are the only requests out of that, Judge. I will inform the court that when you're concluded, we do have an allocution that needs to be done.
And Mr. Hardy, yeah, you must understand that if you fail to completely follow the terms and conditions of probation that will be ordered by the court, that you will be signing onto as though it were a contract, your probation in each of these two cases can be revoked, and you can be sentenced to the full term of confinement that the law provides. And that can be most serious, as you know. Let me see the judgments one more time. Please give those.
Oh, this.
Yeah. So, yeah. Yeah, you're sentenced to 8 years in prison on each of these cases. If your probation is revoked, you can be sentenced to up to 8 years, no less than 2, up to 8 years in prison on each of these two cases. So those are matters that you should heed because if you were sentenced, I believe the parole law requires you to serve 50% of the time. So it would be, if you're sentenced to 8 years, you would have to serve 4 before you could be released in parole. And again, this is a sentence hearing that is suspended at this point and will be continued hopefully by next week, but as soon as possible when the parties are ready.
Yes, sir.
Yes, Judge.
What else do we need to add today?
There's nothing else from the state judge.
Defense.
Nothing, Judge.
We are in recess on these two cases. Thank you. Oh, you have an allocution?
We do, Judge. We ask that you take down.
It is done. And that matter is not by law allowed to be viewed.